got the order out of the Varanasi court. This seems to be a big win for the Hindu side as the
हमारे सारे आर्गुमेंट मान लिया है, मुस्लिम पक्ष की एप्लीकेशन रिजेक्ट कर दिया है, प्लेसेस ऑफ वर्शिप एक्ट की उनकी जो प्ली थी उसको खारिज कर दिया है, वक्फ एक्ट की प्ली को खारिज कर दिया है। देखिए आपने सुना कि इस वक्त की सबसे बड़ी खबर यही है कि कोर्ट ने हिंदू पक्ष की दलील को मान लिया है।
हमारी यही है कि आज घर घर दीपक जले, थाली बजे, शंख जले।
इसमें हिंदू समाज की तरफ जीत हुई है, हिंदू समाज सनातन धर्मियों की जीत हुई है।
Namaste and welcome to this edition of The Nation at 5. I'm Anand Narasimhan coming to you live from the CNN News 18 newsroom. The story this evening, this Monday evening, comes from Kashi. It is with respect to the Gyanvapi Parisar and the plea that was made by 5 women who entered into this plea and said that they have the right to worship the Shringar Gauri shrine in the Gyanvapi Masjid Parisar on the outer wall of the Gyanvapi Masjid Parisar. In Gyanvapi, there are multiple challenges and multiple claims that have been made with respect to Adi Vishweshwar, that is the Shivling, and of course that entire area that was barricaded. But this plea by 5 ladies stemmed from the fact that there is worship of Ma Shringar Gauri, which happens, but it was restricted. And they have come out and said that their right to worship has been impinged upon and they have claimed their right to worship Ma Shringar Gauri. In this case, in my hand is the 26-page order, which also comes as a big win for the Hindu Paksh because the maintainability of this plea was challenged and was challenged by the Waqf Board and the Anjuman Intizamiya who manage the affairs of the Gyanvapi Masjid. But the court has turned around and in this 26-page order delineated and outlined under various parts, whether it is a Waqf Act, whether it is a 1983 Kashi Vishwanath Act, or whether it's the Places of Worship Act 1991. Under all these aspects, they have turned around and said that the plea is maintainable. And now the onus is on the Hindu Paksh to come out and then present more evidence that indeed the nature, structure, character of the structure there is indeed one, Hindu or Sanatan, and 2, that there is actually worship which has happened and continued of Ma Shringar Gauri. More importantly, that there is continued worship which happens, but it has now been restricted. In this very special edition of The Nation at 5, we will break down the entire judgment and try and understand the various aspects of it in detail. The Muslim Paksh has said they will challenge this order as by their right in a higher court and they will approach the High Court seeking the maintainability. But the matter for hearing at the District Court under the judge has been now posted for the 22nd of September. Before we get down to the nitty-gritties or what are the cruxes, the 10 big takeaways from this 26-page order, let's listen into some of the reactions.
सबसे पहला आप वादी थे, आप ही ने सबसे पहले फोटोग्राफ लिया था, आप ही का फोटोग्राफ जमा हुआ यहाँ कोर्ट पर, जिसके बाद कमिश्नर ने कोर्ट कमिश्नर नियुक्त किया गया था। क्या कहेंगे आप?
सबसे पहले सर्वे के दौरान हमने कहा था कि बाबा मिल गए और आज इस विजय की घड़ी में पुनः कह रहे हैं कि यह विजय का जो है काशी विश्वनाथ के शिलान्यास का यह बीजारोपण का बीज साबित होगा। आज का विजय उत्सव, विजय का फैसला
कितना बड़ा दिन है और कितना बड़ा फैसला आप इसे मानते हैं?
सोमवार है, पितृपक्ष चल रहा है और उसमें यह आया हुआ फैसला न्याय की तरफ बढ़ा पहला कदम अवश्य है, लेकिन हम कहें कि यह मील का पत्थर है जहां से हमें विजय दिख रही है, क्योंकि अब चर्चा प्रारंभ होगी। अभी तक था कि यह मुकदमा सुनने योग्य है अथवा नहीं है। मुकदमा सुनने योग्य है, यह तय हो गया। मंदिर के सबूत, गुंबद के नीचे दबा हुआ वह शिखर, गुंबद और शिखर के बीच के 3.5 फीट चौड़े गलियारे की चर्चा, दीवारों पर उत्कीर्ण मूर्तियों की चर्चा और उस शिवलिंग को जो फव्वारा बताने की असफल कोशिश थी, इस पर चर्चा, और फिर शिवलिंग और मां श्रृंगार गौरी के पूजन के अधिकार, इन सारी बातों पे बहस का दौर तो देश में अब प्रारंभ होगा, कोर्ट में अब प्रारंभ होगा और हमें पूर्ण विश्वास है हम विजयी होंगे।
जो राइट टू वर्शिप का ये जो प्रे है, इट इज नॉट बार्ड बाय द 1991 एक्ट। इस आर्गुमेंट पर आपका क्या कहना है, इस ऑब्जर्वेशन पर?
अभी तो हम जब तक उसमें कोर्ट ने जो कहा है अब उसको हम भी पढ़ लेंगे, तो इसका हम लोग राय करेंगे। राय करने के बाद हाई कोर्ट में जाएंगे, हाई कोर्ट में वहाँ वकील से मशवरा करेंगे, इस पॉइंट को हम लोग वहाँ हाई कोर्ट में रखेंगे। जिला जज, सुप्रीम कोर्ट ने जिला जज को डायरेक्शन दिया, उनके डायरेक्शन के मुताबिक जिला जज ने हम दोनों पक्षों की बात सुनी, बात सुनने के बाद एक आर्डर किया। अब इसकी रिपोर्ट वो वहाँ भेजेंगे सुप्रीम कोर्ट। ये हमारा आर्डर सही नहीं कि जब तब तक आर्डर नहीं पढ़ लेंगे तब तो हम कैसे बता दें कि क्या कमी रह गई और कोर्ट ने उस कमी को कहाँ छोड़ दिया, कहाँ ओवरलुक कर दिया। पूजा के अधिकार के, ठीक है, पूजा का अधिकार तो आपका कभी हुआ ही नहीं। आप कहते हैं कि बराबर 93 तक होता रहा, 93 में भी नहीं था। साल में एक बार होता था पूजा, वो आज भी हो रहा है। एक बार साल में होता था चैत में, वो आज भी हो रहा है।
उनको अधिकार है हाई कोर्ट जाने का और वो इस अधिकार का पूरा उपयोग करने का अधिकार रखते हैं, इसलिए हम उनको इस अधिकार से नहीं रोक सकते। और जब बात अदालत में है तो सबूतों पर लड़ाई होगी, तो फिर सबूत दोनों पक्ष प्रस्तुत करेंगे, या तो बाहर बैठ के समझौता हो जाए। अगर आपने आगे बढ़कर के मुस्लिम समुदाय ने कह दिया कि ये 3 स्थान हिंदुओं के, तो बाकी किसी मस्जिद को क्षति ना पहुंच पावे, इसके लिए हिंदू समाज ही लट्ठे लेके खड़ा हो जाएगा। लेकिन कम से कम थोड़ी सी तो दरिया दिली दिखाइए, उनकी भावनाओं का थोड़ा सम्मान करिए। लेकिन चूंकि वो नरसिंहा राव जी की सरकार थी, उन्होंने नहीं माना, विधेयक में हमारे संशोधन नहीं लिए, तो हमने बायकॉट कर दिया था। मैं अभी भी चाहती हूँ कि वो रास्ता निकले।
So let's look at the 10 big takeaways, ladies and gentlemen. The 10 big takeaways from this 26-page judgment. First up, the judgment, and the judge says the suit is not barred by any provision of the Places of Worship Act 1991. Then the judge also says that the foundation has been laid to establish the Hindu character of the property. Says prima facie there is evidence, but the Hindu Paksh now has to come out and embellish that and provide more proof going forward. Deities mentioned existed within the property on and before 15th of August 1947. That's what the Places of Worship Act also underlines. So they said they existed even before that. The Ayodhya case establishes the right to initiate suit to protect the deity. If the deity existed and the religious character was X, then to protect X and the deity there, that right is there as far as the Ayodhya verdict. That's what they've said. Then, Ayodhya case also establishes a legal personality to idols. Here, although the word idols is mentioned, it is deity, and the deity is a living being. That's what has the rights of a living being. Now, and also is perennial in age, and at the established at the time when the Pran Pratishtha happens, the definition of the deity is perennial. That's what the rights are perennial. Destruction does not result in termination of pious purpose. That's another aspect which has been written. Devotees were allowed to freely worship Ma Shringar Gauri till 1993. Now, this is the aspect which is challenged. They said that till 1993, they could go and access the shrine every day. Why has it been restricted to just 2 days in a year thereafter? That's what the devotees had said in their plea. Government of UP in 1993 restricted entry of devotees without a written order. That's what, and plaintiffs are only demanding right to worship Ma Shringar Gauri. That's what the judgment says. This plaint and this plea is purely with respect to Ma Shringar Gauri. The Muslim Paksh allege that this is like a backdoor entry to try and get into this entire area and claim it as part of the overall Gyanvapi Parishad, and also lay claim that the fact that that is the seat, the area of the masjid and the Wazu Khana area, and that area is the seat of Baba Vishwanath. Now, the other part is no suit filed for declaration of disputed property as a temple, saying that the plaintiffs are not saying and they are not coming out and saying that we want this place to be declared a temple. They have said that we worship here and we want the right to worship there. The other part, right to worship is a civil right, and any interference will raise a civil dispute. So these are the points that have been highlighted in this 26-page judgment. Pranshu Mishra is joining us live, and he is in Kashi. Ananya is joining us from Delhi. Before we get into the legal aspect, Pranshu, what's the mood in Kashi? What was the response, reaction? There seemed to be a buzz right since morning because everybody was hoping for a positive verdict because they believe that there is maintainability and the demand is legal because of a precedent. Till 1993, they had open access to Ma Shringar Gauri every day.
Well, so, that has been the basic argument, and you rightly said, the court clearly said that, this prayer is about the right to worship. It is not about determining your religious character, and therefore it is not barred. But talking about the mood, as you precisely asked, we clearly saw a lot of enthusiasm, even since the beginning of the day. There was a lot of hope among the Hindu litigant side. There was a large build-up outside the court, and even many within the the legal fraternity were quite emotionally also attached to this case. So once this verdict came out precisely at around 2:20 p.m., we saw an uproar and outburst of emotions outside the court. Many people started celebrating. There were streets that were distributed. Bam Bam Bole and Har Har Mahadev were the chants which were clearly sounded up. Police, of course, tried to restrain because the concern was that any sort of provocation may not lead to a counter response. But the minority side, the Muslim side, was almost not present there, no build-up there, and they basically decided to go by what the court has said. They have clearly said that they are not happy with the court order and they will challenge it. But on the ground, we haven't seen any sort of protest or any sort of large-scale celebration. So I'll say the police in Varanasi has been successful in curtailing and curbing the people. So what all we saw was, just controlled outside for barely half an hour, 1 hour outside the court. But beyond that, the entire city is absolutely normal. And the credit goes to people of Varanasi. They had been, absolutely normal, living together even in month of May. There was a lot of curiosity going on as the survey was progressing inside the Gyanvapi Mosque area.
Right, Pranshu, great job done tracking that through the day, the stories, and also getting us the stories. We were also the first to also put out the court order, the 26-page court order, and putting out the details. Even the lawyers were the first to speak with us here on the News 18 network. So great job done all around. But Ananya, if we look at the judgment and read through the points very carefully, the judge says that prima facie the Hindu Paksh has established that there were indeed deities there. That means the character of this entire area where the devotees want to worship Ma Shringar Gauri was Hindu and is Hindu.
Well, exactly, Anand. It is a very, very particular point and a very, very crucial point of this judgment that has come in, that a prima facie case has been put forth by the Hindu side in order to take claim of this particular place, saying that the Hindu side has prima facie made out a case that there existed a deity. And remember, since the Ayodhya judgment also had categorically said that once a land is devoted to a deity, it remains to be that of a deity because the deity does not have a life term. It is empirical and in fact goes on for infinity, and hence the land also remains to be of the deity, and hence the prima facie case of the Hindu side has been made out. Apart from that, what is very, very crucial to note is that the court has noted that there is no bar under Section 3 of the Places of Worship Act that bars this suit to be dismissed, that says that the prayers in this particular suit cannot be granted, and it is only a prayer that is the prayer is for only to seek rights of worship that has been asked by the Hindu side, which is not barred under Section 3 of the Places of Worship Act. In fact, it also goes on to say that the arguments of the Muslim side does not sustain in this particular case. If at all they want to say that it's a waqf property, because the waqf can come only into play when it's a dispute between the Shias and the Sunnis, but this is a dispute between the Hindu and the Muslim side. And now what is very, very crucial, Anand, is what comes forward to this. Now what comes forward at this particular point of time is that the Advocate Commissioner's report gains a legal sanctity now because the suit has been made maintainable, and it would be the next step forward. The Advocate Commissioner's report would also be considered into this particular case, and all the other evidence that the Hindu side has constantly been putting forth, whether it's the excerpts from the Skanda Purana, the Shiv Puran, or the British Imperial Court orders dating back to 1800s, which clearly said that this was a Hindu temple that existed at this particular point at this particular place, they would be taken into consideration by the Varanasi court. But the Muslim side would also be approaching the higher court, challenging this particular order before the Allahabad High Court, and then they can also approach the Supreme Court. But what is very, very crucial today, it's a bright sunny day, it's a very, very big victory for the Hindu side, the stepping stone for this legal battle to start on a full-fledged note. Anand.
Right. Thank you for your inputs, Ananya and Pranshu. Let's take this forward. I've got Ashwini Dubey, advocate at the Supreme Court, Aarti Agarwal, author and researcher with us. We should have Madan Mohan Yadav, advocate from the Hindu Paksh, joining us in a moment from now. And I'm hoping that we can get the Purohit or the Pujari whose family traditionally used to worship at the Ma Shringar Gauri shrine over generations. We will try and go across to him also in just a bit. But Ashwini Dubey ji, namaste. Let me ask you this question straight away. First up, that is there a difference between right to worship and right to pray? And then, do the grounds of Places of Worship Act, as the court judgment also says today, do they actually apply? And if they would apply, then it will be the original religious character. In this case, if there is worship that happened till 1993, then does the original religious character not remain Hindu? Are these facts that are undeniable?
Thank you, Anand Bhai. Pranam. Anand Bhai, there are three basic issues. The issues which were framed by the court and very beautifully, with the reasons, by citing the law and by citing the appropriate sections, court has found that the Places of Worship Act is not applicable. The suit is not barred by Section 85 of the Waqf Act, and also suit is not barred by the Uttar Pradesh Kashi Vishwanath Temple Act 1983. As you rightly pointed out, that to offer the prayer, we do not need a place that has been established by the Supreme Court in Ismail Faruqi's case, which came up before the Gyanvapi Masjid case. Gyanvapi Masjid. And to offer the puja, to perform the puja, you need a place. Admitted position is, as you rightly pointed out, that prior to 1993, there was the continuous worshipping of Mata Shringar Gauri. And that has been, there are these statements which says the worship of Goddess Shringar Gauri and other deities were being performed in the precedence of old temple. Avi Mukteshwar was worshipped by its place. And now if we see the today's judgment, what the district court has says, I have come to the conclusion that the bar under section 85 of the Waqf Act does not operate in the present case because the plaintiffs are non-Muslim and strangers to the alleged work created at the disputed property. And relief claimed in the suit not covered under section 35, 33, 47, 48 of Waqf Act. And suit of plaintiff is not barred. The second provision is the Places of Worship Act not applicable because the plaintiffs have not tried to change the religious structure of a building, but they have asked for their pre-existing right which was existing to them. And third, Uttar Pradesh Kashi Vishwanath Act is also not applicable here.
No, and not in this case, if the worship was happening till 1993, then who is denying the devotee their right to pray? Is it not the Muslim Paksh or this entire unwritten order by the government in 1993, which was arbitrary and bad in law? That's another question that arises. I have Shailendra Pandeyji with us at this point. Shailendra Vyas ji. Shailendra Vyas ji, namaste. आपकी तो नमस्ते. आज कोर्ट के इस फैसले को लेकर आपकी पहली प्रतिक्रिया क्या है?
जी सर, बहुत खुशी हुई जान करके ये फैसला हम लोग के पक्ष में आया है और इससे बहुत सा रास्ता खुल गया हम लोग का. पहले से जो बंद था रास्ता हम लोग के केस में भी 91 वाले केस में भी ये लगा हुआ है, हाई कोर्ट में गया हुआ है, रुका हुआ है, वो भी खुल जाएगा. तो इससे बहुत खुशी हुआ हम लोग को.
मैं आपसे जानना चाहता हूँ, आपका परिवार तो पीढ़ियों से वहाँ माँ श्रृंगार गौरी की पूजा करता रहा है, जरा बताइए.
जी हाँ,
तो वहाँ तो क्या
मैं खुद बचपन से लगभग 40-45 साल की उम्र हमारी है, जब से होश संभाले तब से मैं भी अपने नाना के साथ बैठता रहा हूँ और उनके मरने के बाद से अब बैठता रहा हूँ.
तो वहाँ पर हर रोज पूजा होती थी?
हाँ सर, 92 में अयोध्या में जो कांड हुआ उसके पहले तक होती रही लगातार पूजा. हाँ. और उसके बाद जो है कि 92 के बाद रोक दिया गया, साल में एक दिन, सिर्फ नवरात्र की चतुर्थी, चैत नवरात्र की चतुर्थी दिन होता है खाली पूजा.
पर ये किसके कहने पर रोक दिया गया था? इसके लिए कोई आदेश जारी किया गया था प्रशासन द्वारा या फिर किसी ने बस ऐसे ही कहकर ऑर्डर दे दिया था?
जी सर, वो प्रशासन के आदेश से ही हुआ था ऊपर से.
और ये कब 93 तक पूजा होती थी?
हाँ सर, 92 वाला जो कांड हुआ, 93 की जो पूजा हुई थी, उसमें 100 लोग दी गई थी, किसी को नहीं बैठने का अधिकार था। और 93 से सिर्फ एक आदमी को बैठने का अधिकार, वहाँ पर 2 आदमी को, मतलब कि जो रेगुलर बैठते हैं उनको 2 आदमी को बैठने का अधिकार दिया गया था एज ए पुजारी।
तो आप जब आप कितने, आपने आखिरी बार आपके नाना के साथ कब आप बैठे थे, जब रोज पूजा होती थी?
तो उसके 92 के पहले तो डेली पूजा होती थी, कोई रोक नहीं है। 365 दिन की पूजा थी वहाँ पे, कोई दिक्कत नहीं थी, कोई रोक टोक नहीं था, कोई बैरिकेडिंग नहीं थी, सब कुछ खुला हुआ था सब।
जी व्यास जी, आप मेरे साथ फोन पे बने रहिए। असदुद्दीन ओवैसी एक प्रेस वार्ता कर रहे हैं, विल जस्ट गो क्रॉस टू दैट।
तो आज के इस ऑर्डर के बाद भी सुप्रीम कोर्ट ने कहा शैल कंटिन्यू टू रिमेन इन ऑपरेशन पेंडिंग डिस्पोज एप्लीकेशन। तो 8 हफ्ते का टाइम है, 8 हफ्ते का, इसके ऊपर 8 वीक्स का सुप्रीम कोर्ट ने अपने ऑर्डर में कहा था कि 8 हफ्ते का टाइम है। तो 8 हफ्ते के अंदर सुप्रीम कोर्ट का उस पर है। और मैं उम्मीद करता हूं कि इंतज़ामिया कमेटी इस फैसले के ख़िलाफ़ वो अपील करेंगे हाई कोर्ट में। फ्रीज तो है, और 711 का ऑर्डर को उन्होंने आज एडिशनल डिस्ट्रिक्ट जज ने कहा है। मेरा मानना यह है कि ये जो आज ऑर्डर आया है, इससे देश में अब बहुत सी चीज़ें शुरू हो जाएंगी। हर कोई जाकर ये कहेगा कि नहीं नहीं, 15 अगस्त 1947 से पहले से हम यहाँ पर थे, तो फिर 1991 का जो प्लेसेस ऑफ रिलीजियस वर्शिप एक्ट है, वो तो उसका मकसद ही फेल हो जाता है। क्योंकि 91 का एक्ट इसलिए बनाया गया था ताकि इस तरह के कॉन्फ्लिक्ट जो है वो हमेशा के लिए ख़त्म हो जाए। मगर आज के ऑर्डर के बाद ऐसा लगता है कि फिर अब ये लिटिगेशन शुरू हो जाएगा इन तमाम इश्यूज़ के ऊपर, और हम दोबारा 80 और 90 के दहे में वापस जा रहे हैं। फिर इससे अगर खुदा ना खास्ता अगर हम 80 और 90 के दहे में वापस चले जाएंगे, तो ये हर जगह पर एक डिस्टेबलाइजिंग इफेक्ट पैदा हो जाएगा। तो ये हम तो उम्मीद कर रहे थे कि कोर्ट इस तरह के इश्यूज को, जैसे अंग्रेजी में कहते हैं कि दे विल निप इट इन इट्स बड, मगर अब लगता है कि इस तरह का लिटिगेशन अगर आगे बढ़ेगा तो फिर ये उसी रास्ते पर जा रहा है जो बाबरी मस्जिद का लीगल इशू गया था। अब आप बोलेंगे नहीं नहीं, टाइटल नहीं है, वहाँ पर ऐसा करने की इजाज़त दी जाए। अरे भाई, तो फिर कैसा होगा ये? अच्छा, और आप इस बात को समझिए कि ये जो नरेंद्र मोदी भारत के प्रधानमंत्री ने जो बड़ी मंदिर का इनॉग्रेशन किया था ना अभी साल 1.5 साल पहले, क्या आप लोगों को मालूम है कि प्लॉट नंबर 93-94 एक्सचेंज किया गया मुसलमानों से? आप अयोध्या की बात कर रहे हैं? नहीं, इसकी बात कर रहा हूं मैं, इसी काशी की मंदिर की बात कर रहा हूं। प्लॉट नंबर 93-94 को मुसलमानों से एक्सचेंज किया गया। एक प्लॉट लेकर दूसरा घर दिया गया। तो जब एक्सचेंज होता है तो मालिक से होता है ना, मालिक से एक्सचेंज कर रहे हो, और आप आज ही ऑर्डर आ रहा है। ये जो प्रधानमंत्री ने जो इनॉग्रेशन किया, जो पूरे उसको बताया कि मॉडर्नाइज किया गया, उसको तोड़ा गया, बनाया गया, एक्सचेंज हुआ है प्रॉपर्टी का। अब इसको क्या बोलेंगे? और उसके एक्सचेंज के रजिस्टर्ड डॉक्यूमेंट्स हैं, रजिस्टर्ड डॉक्यूमेंट्स हैं। आप बोल रहे हैं कि ये बात कैसे कहते हैं फिर आप? दूसरी बात ये है कि 1883-84 का खसरा है जिसमें लिखा गया प्लॉट नंबर 9130, ये प्लॉट नंबर 9130 है, उसमें उर्दू में लिखा है कि मकबूज अहले इस्लाम मस्जिद। तीसरी बात आप देख लीजिए कि ये जो है प्लॉट नंबर 9130 26 फरवरी 1942 को वक्फ का गजट इशू हुआ था। 1942 को 1942 26 फरवरी वक्फ गजट इशू हुआ था कि ये मस्जिद वक्फ है। दूसरा एक केस हुआ था 1936 का जिसका दीन मोहम्मद वर्सेस स्टेट, 1937 में जजमेंट आया। जजमेंट में कहा गया कि मस्जिद के नीचे की जमीन, घर नॉर्थ और साउथ पे पूरा वक्फ है। अब इससे बड़ा आपको मैं 3 सबूतें दे रहा हूं। फिर ऊपर से 91 का एक्ट है, अगर कोई ये कहेगा कि भाई 15 अगस्त से पहले मेरा कब्जा था, तो फिर 91 के एक्ट के माने क्या है? आप तमाम जिम्मेदार हैं। माने जितने यहां पर जर्नलिस्ट बैठे हैं, जो जब बाबरी मस्जिद का जजमेंट आया था, आप तमाम गवाह हैं। मैंने कहा था कि देखिए ये जजमेंट जो बाबरी मस्जिद का आया है, अब और मुश्किलात पैदा हो जाएंगी, क्योंकि फेथ के ऊपर जजमेंट दिया गया था। अब 91 का एक्ट है और सुप्रीम कोर्ट ने बाबरी मस्जिद जजमेंट में कहा कि भाई जो माजी में जो कुछ भी हुआ उसको हम खोलेंगे नहीं। 15 अगस्त 1947 को जो था वही रहेगा। अब यहां पर ये कह रहे हैं कि नहीं 15 अगस्त से पहले हम हैं, तो अब आप देखते जाएंगे कि एक के बाद एक अब केसेस पढ़ते जाएंगे। इसका असर क्या होगा देश में फिर? नहीं, इसका असर ये होगा कि डिस्टेबलाइजिंग इफेक्ट पैदा होगा।
कुछ लोगों का कहना है कि बाद तक जो 91 का जो वर्शिप एक्ट है उसको लेकिन बाद तक पूजा होता रहा, उसमें आरती होती रही 1993 तक।
नहीं, 91 का एक्ट क्या कह रहा है? अगर आप कोई ऐसा काम करेंगे जिससे नेचर ऑफ द रिलीजियस प्लेस चेंज हो जाता है, तो फिर 91 का एक्ट किस माने में रखता? बोलिए आप, क्या माने रखता? चाहे मस्जिद हो, चाहे मंदिर हो, गिरजाघर हो, कुछ हो, अगर कोई ऐसा काम होता है तो फिर वो उस प्लेस का नेचर ही चेंज हो जाएगा ना। ठीक है, अभी तो ये 7/11 का ऑर्डर आया है, सुप्रीम कोर्ट का जो 20 मई का ऑर्डर है, उन्होंने 8 हफ्ते का उसमें फ्रीज लगाया है। अपील होनी चाहिए, अपील जरूर होगी। और मगर ये इसके आप मैं तो एक लेमन की तरह समझने की कोशिश कर रहा हूं कि 18।
Well, so Asaduddin Owaisi is saying that the order could have a destabilizing effect. Aarti Agarwal, how do you want to respond to that?
I think Owaisi finds every order to have a destabilizing effect. So, he's interpreting every law, every judgment in his own way. There is a certain system, there's a certain method to what exactly it means to change the religious character of a place. He is interpreting it in whichever way he likes. So, whereas we are very clear that we want to continue with the right to worship at the Mata Shrinkar Gauri deity, and that is, as we have already discussed, is a perennial right, and there was no legal basis for from worshipping there. So, he cannot just come up with his own opinions and present it as a legal case. There's a certain system to it. So I think Mr. Owaisi finds everything very destabilizing, and I want to ask that why is it that so? Because nobody is fighting right now. I mean, what is his reason for interpreting it as destabilizing? Is he stoking unrest by saying this? Is what my question is going to be. It's almost like a recommendation from him that it should be destabilizing for the community.
No,
it's not.
He's turning around and saying that there will be plaintiffs, plaints or pleas across the board, and there will be everybody and anybody will raise this question. And Ashwini Dubey, how would you want to respond? That the Places of Worship Act 1991 was put in place so that these disputes were settled, and it doesn't happen. But now this is going to be unsettling. Everybody is going to now hold on to 15th August 1947.
Anand bhai, Mr. Owaisi has discussed about the Deen Muhammad. I will come to your question later, at a later part. Yeah. The judge has discussed the Deen Muhammad case, and I would like to read the operative portion for viewers point out. In civil appeal number 466 of 1937, Deen Muhammad versus Secretary of State, Honorable Allahabad High Court upheld the judgment and order dated 24th August 1937, passed by Civil Judge Senior Division Varanasi, and dismissed the first appeal. Therefore, by order of the Court of Civil Judge and Honorable Allahabad High Court, the mosque, courtyard, Sahnanand and land apparent to its property of Hafi Muhammad work when Hanfi Muslims have right to offer namaz. What court has said? Court said the argument of defendant number 4 does not seem to be convincing, because as learned counsel for the plaintiffs argued that Hindus were not parties in the above suit, and their application for implementing the suit was rejected. So Anand bhai, if suppose an order is passed against you without making you as a party, how it is enforceable against you? Point number 1. So, and point number 2, you have said about the Places of Worship Act. Anand bhai, Places of Worship Act is applicable in a case where we are trying, or somebody is trying to change the basic character of the building, Here is the section 4 lays down that the injunction of law shall not operate with respect to any place of worship. It is an ancient historical monument or an archaeological site, and also when the suit has been filed with the pre-existing right to perform the puja which was being performed up to 1993, even after passing of the 1991 Act. So by virtue of an arbitrary, unjustified order of a state government, if right to worship, which is the fundamental right, was taken away, then how can the places of worship act will operate? And I think the honorable judge has categorically dealt with this issue.
But in this case also, when Mr. Owaisi is making an argument, Aarti Agarwal, why if they were allowed, if the basic character was Hindu and they were allowed to go and pray on a daily basis, then if they are stopped from breaking a prayer, then whose right is being impinged upon? So does the right to pray exist only for certain sections of society and does not extend to the other section? And if there was a right to worship, why can't that be facilitated? Nobody is saying that you give us, that's what the ladies are saying. We want the access to the outer wall where Ma Shringar Gauri shrine is. We are not saying give us the entire part which is under Waqf. He also quoted the Waqf Act, and the judgment very clearly says these are non-Muslims. If it is a Shia versus Sunni case, then the aspect, then it is then the Waqf Act comes into place. Here the Waqf Act doesn't apply, is what the judgment says.
Right. So I think one thing is important to mention here, that we are not asking for the exclusive right to worship or pray. We are allowing the other side to continue as well. And that is something which I think, Mr. Owaisi and his ilk are completely glossing over. We are not impinging on their rights. We are just asking to restore our rights. And this judgment is very important because, at least my contention since the beginning has been that at least the Hindu side should be heard. At least our rights should also be acknowledged. We are at least not, asking for, again, exclusive right, but our rights should at least be acknowledged and entertained in a court of law, where we are proceeding in a very systematic way. We are giving all the evidence. We have gone through a legal process for the... We are again going to pursue that legal course. So, we are presenting all facts, all evidence, following every law to the letter. So, why should it not be entertained? And this particular plea is very important because this is exactly the question that, they said that they are rejecting the Muslim side's contention that the plea is not maintainable, right? That means our point is maintainable. That means we can proceed forward as we have been going forward. I mean, this is a good precedent for us because, this means that at least we have some justice for our Hindu right to worship also in this country, which is
in this case, in this case, the aspect is if there is a right to pray, that extends to everybody. Worship is unique to certain communities. So worship is an act which is conducted only with certain communities. So will that delineation also come out and challenge? And Ashwini Dubey, if one person or one side or one individual of the country, one citizen can go ahead to court and challenge a law that's been passed by Parliament, why can't another individual go and challenge another law that's been passed by Parliament, and prove that it's bad in law, and that's why that law has to be changed? That's one dynamic. The other dynamic is that if somebody can claim a right to pray because they've been praying there for 600 years, then why can't the others claim the right to pray because they've been praying there for 600 plus another 600 years?
Anand bhai, that's the basic question. See, Anand bhai, in the Places of Worship Act, the court has discussed how beautifully court has passed the order that conversion, this matter does not relate to conversion of any place of worship of any religious denomination or any section thereto into place of worship of different sections of the same religious denomination or of a different religious denomination, which is prohibited. Now, very candidly, you have said that the place worship and prayer both are different. The Places of Worship Act is specifically referred about a certain class of people. It does not include the all walks of the society, people who are living in this country. Means this act is arbitrary and center has transgressed not only the state domain, why it is a state domain? Because religious matters are all within the state list. State has to take a call. We as the center, without discussion with the state governments, have passed this order and have taken the right to judicial remedy. And right to judicial remedy is a fundamental right. And now another question which is, it will open the Pandora's box. देश में वैसे भी हजारों मुकदमे पेंडिंग है, लाखों मुकदमे, 200-300 और पेंडिंग हो ही जाएंगे इन द कोर्ट्स, एंड कोर्ट्स बेस्ड ऑन द एविडेंसेस इफ कम्स टू द कंक्लूजन दैट द प्लेस व्हिच इज existing as of now is not hit by the provisions of Places of Worship Act, and when somebody is asking that I should be allowed to perform my prayer or perform my worship because this is the fundamental right under Article 25 of the Constitution of India, and also right to restore is a fundamental right as per Article 29 of the Constitution of India. So where basically there is a problem in this judgment. I think this judgment is very categorically considered all the aspects, for the applicability of the Waqf Act, for the places of applicability of the Places of Worship Act, or also Uttar Pradesh Kashi Vishwanath Act 1983. Over to you, Anand.
Ji, now there is also this aspect, the last page, and I want your thoughts on this. In section 4/9, temple has been defined as the temple of Adi Vishweshwar, popularly known as Sri Kashi Vishwanath Temple, situated in the city of Varanasi, which is used as a place of public religious worship and dedicated to and for the benefit of or used as of right by Hindus as a place of public religious worship of the Jyotirling, and includes all subordinate temples, shrines, sub-shrines and the ashthan of all other images and deities, mandaps, wells, tanks and other necessary structures and land appursuant thereto, and additions for which may be made thereto after the appointed date. From the perusal of the above mentioned provisions of the Act, it is clear that no bar has been imposed by the Act regarding a suit claiming right to worship idols installed in the endowment within the premises of the temple or outside. Therefore, defendant number 4 has failed to prove that the suit of the plaintiffs is barred by the UP Sri Kashi Vishwanath Temple Act 1983. So again, they cited Kashi Vishwanath Act 1983, POW Act 1991. On all these grounds, the judge turns around and says, you cannot stop somebody from praying. If you are allowing them to pray twice in a year, why can't they pray 365 days in a year? It's a simple question, Aarti.
Right. So I think, the most important question here, at least as per me, is that Owaisi is interpreting the Places of Worship Act wrong. He's interpreting it wrong. Secondly, he is not seeing that the judgment is already accounted for whatever his complaints or his grievances about the act itself are, because as you just read out the whole judgment, it has already taken into account the Places of Worship Act, and it has there has been no contradiction between what we are asking and the Places of Worship Act. Thirdly, he's saying that if we are trying to maintain the religious character of a place as it was in 15th August 1947, the act does not make any sense. So I think it's a bit too late to say that the act does not make any sense. I mean, he's waking up very late to decide that the act is not making any sense. I mean, the act has been in place for all these years. Where was he to now? Now because, he wants to use that act or misinterpret that act to, stop this judgment or stop this, pursuit of this justice. Correct. He suddenly thinks that the act is not making sense. You can't arbitrarily wake up one day and say that this particular act which was passed in 91 is not making sense in 2022. So, and if that is his contention, he needs to go to court and pursue, that course instead of just making
and not just that. There is an argument which very clearly says that there is a difference between praying and there is a difference between worshipping. And worshipping is intrinsic to the Sanatan Pratha. Prayer is something which is common to all. Worship is when you install a deity, you believe that deity is a living being because you do a certain level of kriya and there is an action of prana pratishtha that is made. And that's why you go ahead and worship at that particular spot. And that area which once legally established and set there as far as the Vedic, the Agamas and the Agama Shastra and how it is done, in that case, the prana pratishtha, that area is supposed to be the right of the deity perennially. The deity is supposed to be sitting there and presiding over that area perennially till the time the deity with due vidhan is moved or a visarjan or a consecration is done elsewhere. So all of that is a process which has been established, and the deity has living rights as per the constitution and as per the laws of our country, and the courts have also upheld that. Ashwini and Aarti Agarwal, thank you very much. Before we take a short break, quickly going through the top 10 takeaways of this 26-page judgment once again. The suit is not barred by any provision of the Places of Worship Act, point number 1. Point number 2, the foundation has been laid to establish Hindu character of this property. and deities mentioned existed within the property before the 15th of August 1947. They existed even after the 15th of August 1947. That character had not changed on the 15th of August 1947. Ayodhya case establishes right to initiate suit to protect the deity. Also, Ayodhya case also establishes a legal personality to the idols when they are installed as deities. Destruction does not result in termination of pious purpose, and devotees were allowed to freely worship Ma Shringar Gauri till 1993. Places of Worship Act 1991, but this is till 1993 it happened. The government of UP in 1993 restricted entry of devotees without a proper written order, and that's what has stood out. The plaintiffs are only demanding the right to worship Ma Shringar Gauri. There is no plan to change the nature, the intrinsic nature. The last point, that no suit has been filed for declaration of the disputed property as a particular temple. The right to worship is a civil right, and any interference will raise a civil dispute. That means if I can give one person the right to pray, I cannot do it at the cost of denying another person the right to pray at a place where they've already prayed. We're going to take a very short break here on The Nation at 5. Stay with us.